Please like and follow for more. There's a moment every landowner dreads, when someone tells you their stormwater is suddenly your problem. Here's the truth most homeowners never hear until it's too late. You cannot be forced to absorb someone else's engineered runoff. Not their pipes, not their drains, not their "it's always flowed this way" stories. Stormwater law draws a bright line between natural flow and artificial diversion. Natural flow is the water that travels the land the way gravity intended. Artificial diversion is when someone installs a pipe, trench, basin, or channel to push water in a direction it was never meant to go. The moment a neighbor or their family ties into a drainage basin, concentrates flow, or discharges non-stormwater into a public right-of-way that then gets blasted onto your land, the law calls it what it is. Trespass, not a prescriptive easement, not a historic pattern, not your responsibility to babysit. Courts across the country, including South Carolina, have said the same thing for decades. A prescriptive easement cannot rise from unlawful conduct, and water that's been channeled, pumped, or piped isn't natural, it's manufactured runoff. If that water floods your yard, undermines your slope, erodes your shoreline, or forces you off your own property, you're not the cause, you're the casualty. No homeowner is required to sacrifice their land so someone else can avoid fixing their own drainage. The law protects the lower property from being turned into a dumping ground for upper property shortcuts. And when someone misrepresents that water as natural stormwater or hides the pipes that caused it, the legal narrative collapses fast, because the truth is simple. If it didn't originate on your land, it isn't your burden. Follow for the next episode, how to identify artificial diversion and prove it, even when the evidence is buried. Every piece of land has a story. Follow Land Unlocked to uncover the laws beneath it.